Hello guys, and welcome to another episode of my lecture. In my last lecture, I discussed about the de facto director, the de jure director, as well as the shadow director, and I also discussed about the relevant provisions relating to these directors. In this particular lecture, I will be discussing about the executive director and the non-executive directors. Who are they? Let's look at the Cama to find out. Now, the first place that we need to go is section 269 subsection 2. What does it say? If you are with your Cama with you, you would realize that section 269 subsection 2 is the section that grants rebuttable presumption in favor of third parties dealing with the company, where the company describes a person to be its director, as that person shall be duly appointed. There is a presumption that that person is duly appointed where the company describes him as a director. Now, there is a particular provision there that says whether executive or otherwise, where it describes it as its director, whether executive or otherwise. It then tells us that apart from the executive directors that we all know, there is something called the non-executive director. So therefore, let's start first. Who are the executive directors? Another name for the executive directors are inside directors. And an executive or inside director is one who is an employee of the company. He holds a position in the board of directors and has an executive responsibility for running the company's business. Companies need executive directors for their information value as well as their staff in management. Executive directors are usually head of specific positions, or they hold key positions in companies. So for example, you have risk management, you have finance officer, you have MD and all that. Now, the head of all executive directors is the managing director, also known as the chief executive officer. So when all the executive directors are seated, there has to be somebody to head them. The person heading them is the managing director or the chief executive officer. He is the number one director of the company and is usually responsible for the day-to-day operation of the organization, which includes managing committees and staff, as well as developing business plan in collaboration with the company. The managing director assumes leadership role for an organization and often fulfills a motivational role in addition to office-based work. The position of the managing director is quite special in that while the board of directors can terminate the employment of the managing director as the chief executive officer, as seen in section 88B of Cama, only the company can terminate his office as a director, as seen in section 288(1) of Cama. Now, when we are talking about removal, I am still going to discuss this extensively in another section entirely, where we'll be discussing the Bumi Onis case, the longest case, Iwuchukwu versus Iwuizu, and the rest. We have a lot to discuss, but those are things that I'll be discussing in another segment entirely. Right now, what is most important to us is to understand who an executive director is. An executive director, first of all, must be an employee. You don't just jump from anywhere and enter into a company. You must be employed first. So most of the time, the cadre starts from probably you being an office assistant. From there, you are promoted to secretary. From there, you are promoted to this and promoted to that until you get to the board. Do you understand? Most times, promotion is based on certification. So while you might have been an office assistant as a BSc holder, during the course of your employment, you must have gone to further your education by having your master's or your PhD or one professional qualification or another. When that is the case, the more your qualification, the more you are likely to get promoted. And such promotion is done in that manner until you are likely to get to the board to be a director. So first thing first is that you must be employed in a company before you are then put on the board of director as one of the directors of the company. That is that for the executive directors. So we then go to the non-executive directors, also known as who? Outside directors. They are not employees, as there is no employment contract. Their only capacity is that of a director. A non-executive director are members of the board of directors without being members of the executive management team. They are not employees or affiliated with the company or any matter than serving on the board because of their value, because of their quality, because of their capacity and experience. Basically, non-executive directors are brought to provide a creative contribution and improvement to the board by providing dispassionate and objective criticism. They are not involved in the daily management of the company. Instead, they monitor executive activities and contribute to development strategy. They are usually people of stature and experience who can act as a source of wise, independent advice and a check on the board. They are expected to bring impartiality, independent, wise experience, special knowledge, and personal qualities. It should be noted though that non-executive directors are independent or non-independent. When they are independent, it means that they have no connection with key members of the company and are brought primarily to help the company with independent, objective decisions. But when they attempt to be non-independent, it means that they are related to shareholders or key members of the board, and as such, they may be biased on their decisions due to their personal interest. You see, when you are talking about these kind of people, I want you to Google, if you can, the current head of the World Trade Organization, that is Okonjo-Iweala. She was Nigeria's former finance minister on 2 occasions. She was also the managing director of World Bank at the time. Now, if you look at Okonjo-Iweala, she was appointed as a non-executive director of Twitter in 2018. And then your question would be, why did they appoint her as such? She has a very vast experience when it comes to finance. Twitter definitely knows that, and then they decided to put her on their team. Note that if she were to be a director, it means she must have been given a letter of employment, because to be a director, you must first be employed to the company to serve in a high capacity that has to do with the direction and management of the company before you can sit on the board of director as an executive director. In this case, Okonjo-Iweala is on the board for Twitter. However, she's not an executive director. She is only a non-executive director who is there to give criticism, objective criticism, and counsel, wise advice where there need be. Do you understand? When I was reading the story in 2018, Twitter had made a very huge profit. They were looking for the best counsel on how to invest and manage that profit. And they needed that counsel from somebody who could be on their board, who can give them a good counsel. They decided to make Okonjo-Iweala a non-executive member to give such counsel. Do you understand? So on a board, it is important to have the executive directors, but it is as well as important to have the non-executive directors to give guidance, because if you are in a board, you will know that a company has a lot of facets. He has the one for technology, he has the one for communication, he has the one for finance, he has the one for its business, he has the one for transportation. He has so many areas. A particular director can have so much experience when it comes to the legal facets, but when it comes to the technology, a person who has only legal experience would not know that. When it comes to transportation, a person who has experience in mass communication might not know that. So you then need certain people to then be on that board to give you advice and also to give you independent counsel and objective criticism as to your step. That is the essence of these people. According to the Corporate Governance Code 2.3b, it specifically recommends that most non-executive directors are independent. Conclusively, as seen in the whole of the Principle 2 of the code, the board ought to involve an appropriate mix of executive, non-executive, and independent non-executive directors, such that majority of the board are independent non-executive. Why did he say that? Because most of the time in a company, they need a lot of rich expertise to be able to make decisions, not just ordinary decisions, informed decisions. For you to be able to make informed decisions, you need experience and expertise to give the counsel. If there is no right counsel, there would be no good decision. Good decision is based on right counsel. Right counsel is likely to come from independent, non-executive members. Do you understand? So now we move on. According to a recent decision of the Supreme Court of Victoria, per Justice Dixon, in Jacks versus AIG Australia, which is a 2014 case, the essential characteristics of an executive director is that he or she discharge, usually as an employee of executive function in the management and administration of the company. Non-executive directors are usually independent of corporate governance. When it comes to the governing of the company, the non-executive directors are not, that's not their business. What their business is the administration of the company. When I mean administration, I mean how it administers its business. So in relation to that, they give very wise counsel. The managing director is usually employed in implied terms that the CEO exercises care and skill expected of such person in his position. In contrast, non-executive directors aren't bound to give continuous attention to the affairs of the corporation. Their duties are of an intermittent nature to be performed at periodic board meetings. So with that, I think we've wrapped all the types of directors that we have, from de jure to de facto to shadow to non-executive and then to executive directors. Now we need to interrogate the case laws as regarding all these things. In real practice, how do they interplay? One of the most important cases that explain in total details each of these types, especially for shadow, de facto and de jure, is the case of Ray Holland, also known as Holland versus Commissioner of Her Majesty Revenue and Customs, Ray Holland. We will be discussing about this case in my next lecture. See you in my next class.